is in the restaurant of the parliament, and here are some stakeholders which were invited to a conference of us. And this is a kind of blown up statue that was created at Place du Luxembourg, was erected there. This is very close to the parliament and the public space somehow. So I wonder how they managed to erect this statue there. So we try to be present in Brussels, but of course you don't win such a debate with T-shirts and balloons, but
and statues.
With discussing the issue with parliamentarians. And I think it's very important that there's a lot of regulation going on the European level, that everybody who's concerned about it shall cast an eye on these proposals, look it up, give feedback, analyze texts, get to the real source code, so to speak, of law, because I mean, changing law is very similar to, say, changing software. Patches are called amendments, and Parliament votes about amendments to those proposals, and so you have to edit the text, and editing on one side could have effects on other, and often it's a kind of what happens then machine implemented in this stuff. Well.
Try not to crash it.
Okay. I have another interesting document here, just to demonstrate here. Ach, hier bin ich noch nicht raus. Ach, du Scheiße. Okay, so these are the amendments that were introduced, a part of the amendments that were introduced inside Parliament, and such a document which is prepared by the tabling office then looks like that you have an amendment, the amendment has a number, one side is the position of the council or the basis text, and on the right side you see the change proposal. This proposal here, Amendment 42, was proposed by Barbara Kudrycka, Tadeusz Zwiefka, I don't know them. And then you have below, you have a justification. And often these change proposals are tabled by many different MEPs, and there are a whole lot of them, and you can use the justification to introduce some ideas. It's common practice that these amendments are proposed by lobbyists often, and actually we wrote amendments for MEPs and presented them to the MEPs and asked them to sign them for the tabling office and things like that. So it's like when you contribute a patch to software and you need the approval of some core developer or like that, because you don't have access to the system. And then there's a vote about these amendments, and these amendments then get applied to the text. And often there are some conditions and within the text, kind of hypertext. And in our vote, there were a lot of amendments, and because we prepared all these amendments and we had all the whole set of amendments, our opponents, which I think in fact were stronger at this stage of the debate, but they suddenly bailed out. They said, okay, we stop this here, and we want to reject the directive. So in the end, everybody was happy because the directive was rejected. But what we actually wanted was a better directive, And this is a directive which includes interoperability provisions, which clearly rules out software patents and so on. So we don't have this legal validity, legal security yet. And for this purpose, other directives are useful, other legislative projects, and for this purpose also the community patent is an interesting issue. And there are some motions on the national level in Parliament in order to define these terminology terms. What is the field of technology? All this complicated stuff. What is technical, and so on. Especially interoperability rights is something which needs to be addressed on the European level, and there are many opportunities, and the time is really good for that, because there's a kind of inter-industry support for the issue of interoperability.
Well, we were just talking about the amendments, and in that sense, I want to encourage you to, if you hear about issues that turn up like software patents or like the data retention directive, you can go to the EU web servers and you can download the document, and then you look at it and you sit down for, say, half an hour, read the document, and then you sit down for another 10 minutes and have your set of things that you dislike about the directive, and you just type them in. You say, this needs to be changed in my opinion, and this is a better way to do it. Of course, you need to get a clue about how to express yourself, but I think some of you have a very good opinion. And then you can propose these amendments. And the thing is, even if you have some mistakes in your formulation, then these amendments won't get adopted as they are, of course, but they will pass through MEPs, through their parties, and they will read them for you. And if they think, oh well, this sounds like a good idea, and some of them do think this, then they will just correct your mistakes. So don't be shy.
Okay. I just wanted to add, I think we cannot get through with all these issues, but about the WIPO. The WIPO is a very interesting forum. It's in Geneva, a UN institution, which is responsible for some copyright treaty, and it's often referred to as forum shifting from the WIPO to the WTO. It's a diplomatic body. The people there are very diplomatic, and when you get accredited to the WIPO, you get a whole lot of documents which are mostly baseless, really baseless, what's written there, because this is diplomatic speech, another level of discussion, so to speak, which is very difficult for pragmatic people. And you know, on the Parliament level, it's always said that Parliament is a kind of, by anti-democrats, that Parliament is kind of talking booth. But in fact, it's the case that in governmental structures, like in third world countries, in dictatorships, there's much more of insubstantial discussion, and this also applies to the diplomatic level at the WIPO. But there are interesting things going on because NGOs made inroads. There was an alliance called this year Friends of Europe. I think there will be another talk about this at this meeting. Friends of Europe, which included a whole lot of NGOs, and they introduced a proposal for access to knowledge treaty. Now, I believe that this proposal is not very good, but it addresses a lot of issues like interoperability and other exceptions, especially for the developing nations. And it was put forward by Brazil and India, and they are somehow the leaders of the third world countries, or the G20 countries. So this is now equally discussed on this diplomatic forum. What I have here is the planned budget for WIPO, and there's something which concerns me a lot about the whole debate. I personally have a kind of liberal opinion, perhaps a little bit idealistic. I think our constitution says that public opinion building is one of the role of political parties. And I think civil society also contributes to build, help you to assist, to create your own opinion. But in the end, our representatives, Parliament, shall decide about legislative acts and control the government, which is elected by Parliament. What people are often not very concerned about is the fact that in reality institutions often have strong institutional interests. This also includes WIPO. And especially in this area of so-called intellectual property or patent law, we often see the strange thing that governments or these institutions take part in lobbying themselves. And when you look at the WIPO strategic framework, something in the UN papers which you always have to be very aware of, that something is wrong, but it's common on the international level, is when you listen to phrases like promotion of good health, promotion of intellectual property or like that, because this is always somehow associated with propaganda events on the one hand, or where these international institutions somehow lobby parliament or lobby governments. So governments somehow lobby themselves. We have to finish soon. And now here, for instance, this program here on page 32, to promote an IP culture. And they have lobbyists at the European Parliament and so on. This is an international organization and they lobby Parliament, which is quite strange. And this is very common in this area of law. And here they have 30 million Swiss francs for 2006-2007 for this single project and, you know, and so on. But these international organizations, and this is our reform request, don't provide the kind of information which we really need, urgently need. This is like economic analysis. Whole WIPO employs no economist. I asked the Director General and he said, no, we don't have economists because economists are too expensive now. WIPO has a budget of 500 million. So this sounds a little bit fishy, but the problem is that the real analysis, like economics of the patent system, how does it work, how can the quality be improved, how can it get speed up, this kind of analysis is not really provided by the institutions, and instead somehow the system is promoted. And so we have a situation where it a little bit compares to a kind of sweet porridge device. So, you know the story of sweet porridge. Now, more is better. We need more protection. We need more enforcement. But this is like, well, like driving a car and someone says, oh, you have to speed up and be faster. And anytime you hit the brake, you get electrocuted by your co-driver. So this is not really what we want. We want good driving and we want fast driving and we want a good working patent system and not such general baseless promotion of the system as a means in an end. Now there are a lot of programs. These programs are always very general. When you look at this language, which is really awful, expected results, strengthen ability of member states, in particular business and research institutions, to develop and manage IP assets. All this is very general, and there are a lot of other programs here, 12 million for this program, and so on. What I found useful is that these institutions start to change and improve a lot when you discuss what they are doing, because what these institutions do is a lot of is very intransparent, and the internet gives us a great opportunity to view all the documents, to analyze what they do, to report about